Hello guys, by the way, how are you? Happy New Year 2023. I know the results are out. Yeah, the CPA's results, and I know some of you, by the way, performed well. You passed the section that you were in, and I know that some have got refers. Others have graduated, by the way, but that's part of life. So for those who have refers, don't give up. This is Ernest Masharia, CPA. I've passed through that. I started in the lowest level, that is ATB, and now I'm a CPA. So don't give up. Just try and try again. And one of these days, utakuja kumaliza CPA. So for today, nilikuwa nimemwahidi for CPA classes, and because the exams are out, I know you know where you are heading to. So if you are in section 1, 2, you are now heading to section 3, 4. And if you are in section 3, 4, you are heading to section 5, 6. And also to the CAMs and ATDs, you know where you are going. So for today, I'll start with the CPA 1, 2 guys. And I have a small topic or topics that we can cover together, and that is in law and governance. So find a book and a pen. We shall take some notes for this. And in law, we just need to read, reread, understand, let it stick in your mind, be it on your fingertips. Yes? So I know now you have got a book, a pen, and somewhere to sit and take notes. And let's start with the first topic in law and governance. And topic 1 is elements of the legal system. We are writing, so let's start. Topic 1, elements of the legal system. Under that, we have some topic, nature, purpose, and classification of law. Nature, purpose, and classification of law. And first, we shall start by defining the term law. What's the meaning of the word law? And law, simplify, refers to the set of rules which guide and conduct in the society and enforceable by the state via public agency. I repeat, it refers to the set of rules which guide our conduct in the society and is enforceable by the state via public agencies. So, nature of law. There are several different natures of law, and we shall start by defining them. And number 1, nature of law. The different schools of thoughts that have arisen are all endeavors of jurisprudence. Yes? The different schools of thought that have arisen are all endeavors of jurisprudence. Natural law school, positivism, realism, among others. It is these schools of thoughts that have steered debates in parliaments, courts of laws, and others. All right? So, let's proceed. We have several natures of law, and one, natural law. Natural law theory asserts that there are laws that are immanent in nature, to which enacted laws should correspond as closely as possible. All right? Number two, legal positivism is the view that the law is defined by the social rules or practices that identify certain norms as laws. Number three, legal realism. It holds that the law should be understood as being determined by the actual practice of courts, law offices, and police stations, rather than as the rules and doctrines set forth in statutes or land treaties. Number four, legal interpretivism. Legal interpretivism is the view that law is not entirely based on social facts, but includes the morally based justification for the institutional facts and practices that we intuitively regard as legal. All right? Then, let's proceed. There are several characteristics of law. Several characteristics of law. Number one, it is a set of rules. It is a set of rules. Number two, it regulates the human conduct. It regulates the human conduct. Number three, it is created and maintained by the state. It is created and maintained by the state. Number four, it has certain amount of stability, fixity, and uniformity. It has certain amount of stability, fixity, and uniformity. Number five, it is backed by coercive authority. It is backed by coercive authority. Number six, its violation leads to punishment. Its violation leads to punishment. Number seven, it is the expression of the will of the people and is generally written down to give it definiteness. It is the expression of the will of the people and is generally written down to give it definiteness. Number eight, it is related to the concept of sovereignty. It is related to the concept of sovereignty. So that's a point to note. Characteristics of law. It's a common question asked in law papers. Let's proceed to another subtopic. Purposes of law. And number one, it promotes peaceful coexistence or maintenance of law and order. It promotes peaceful coexistence or maintenance of law and order. Number two, It is a standard setting and control mechanism. It is a standard setting and control mechanism. Number 3, it protects rights and enforces duties by providing remedies whenever these rights or duties are not honored. It promotes rights and enforces duties by providing remedies whenever these rights or duties are not honored. Number 4, facilitating and effectuating private choice. Facilitating and effectuating private choice. Number 5, it resolves social conflicts. It resolves social conflicts. Number 6, it controls and structures public power. It controls and structures public power. Number 7, government and confer upon them the power exercisable by them. Sorry, I repeat, government confer upon them the powers exercisable by them. That is, those are some of the purposes of law. Then, another subtopic, we are still writing, classifications of law. I've said severally, law just needs you to have notes, read, reread, and understand. Let all the notes stick inside your mind or your head. Let them be on your fingerprints. Yes? The first characteristics of law you can give. Purposes of law you can give. Then let's proceed with our next subtopic, classification of law. It can be classified as follows. 1, written and unwritten. 2, municipal and international. That is municipal stroke national and international. Number 3, public and private. Public and private. Number 4, substantive and procedural. Substantive and procedural. Number 5, criminal and civil. Criminal and civil. And let's define all those classifications. We've said there are 5, so we start by 1, written and unwritten. What's a written law? This is confined law. These are rules that have been reduced to writing. Alright? These are rules that have been reduced to writing, e.g. Constitution. E.g. Constitution, Act of Parliament, delegated registration, international treaties, etc., etc. Number B, unwritten law. These are rules of law that are not contained in any formal document. These are rules of law that are not contained in any formal document. E.g., African customary law, Islamic law, equity, case law, common law, etc. Number 2, municipal stroke national law. This refers to rules of law that are applicable within a particular country or state. This is a state law. I repeat, this refers to rules of law that are applicable within a particular country or state. This is a state law. E, international law. This is a body of rules that generally regulates the relationship between countries or states and other international persons, e.g. the United Nations. This is a body of rules that generally regulates the relationship between countries or states and other international persons, e.g., United Nations. B. Public laws. It consists of those fields or branches of law in which the state has a direct interest as the sovereign. It consists of those fields or branches of law in which the state has direct interest as the sovereign. Let's proceed. Number four. Substantive and procedural. We start by substantive. Substantive. It consists of the rules themselves as opposed to the procedure on how to apply them. It consists of the rules themselves as opposed to the procedures on how to apply them. Examples of substantive rules. Number one, the rule of thought, the rule of succession, the rule of contract, the rule of marriage, the penal code. B. Procedural rules. This is adjectival rule. This is adjectival rule. It consists of the steps or guiding principles or rules of practice to be complied with within the administration of justice. It consists of the steps or guiding principles or rules of practice to be complied with in the administration of justice. Examples: the Civil Procedure Code, the Criminal Procedure Code. Then, let's proceed another subtopic. Sources of law. The various sources of law in Kenya. Sources of law. Number one, Judicature Act. Judicature. Judicature. Act. Constitution. Hindu Marriage and Divorce Act. Hindu Succession Act. Kadhi Courts Act. Sources identified by the Judicature Act are: 1. The Constitution. 2. Registration. 3. Delegated registration. 4. Statute of General Application. 5. Common law. 6. Equity. 7. Case law. 8. African customary law. Sources identified by the Constitution and the Kadhi courts are: Islamic law. 3. Sources identified by the Hindu Marriage and Divorce Act and the Succession Act. Hindu law. Sources of law of Kenya may be classified as: 1. Written and unwritten sources, principal and subsidiary sources. Let's define what a constitution. The Constitution. A constitution is a public document which regulates the relationship between the state and its citizens, as well as the relationship between the organs of the state. In Kenya, the Constitution of Kenya is a source of law from which all other laws derive their validity. Any law which conflicts or is inconsistent with the Constitution is void. That is in Kenya. I don't know. What about Uganda? Rwanda? Act 2, bracket 4 of the Constitution provides any other law is inconsistent with the Constitution, the Constitution shall prevail and the other law shall be, to the extent of the inconsistency, be void. Alright? I repeat, Act 2, bracket 4 of the Constitution provides any other law is inconsistent with the Constitution shall prevail and the other law shall be, to the extent of the inconsistency, be void. Let's see some issues addressed in the Kenyan Constitution. Issues addressed in the Constitution of Kenya. And I'm talking about the 2010 Constitution, the new Constitution. Number 1, the people of Kenya are the sovereign. Number 2, the supremacy of the Constitution. Number 3, the Republic. Number 4, the Bill of Rights. Number 5, citizenship. Number 6, leadership and integrity. Number 7, representation of the people. Number 8, separation of powers. Number 9, devolved governments. Number 10, matters of public finance. And number 11, amendment of the Constitution. Let's see another subtopic, supremacy of the Constitution. Supremacy of the Constitution is provided for under Article 2. All other sources of law derive their validity from the Constitution and are therefore required to be consistent with all provisions of the Constitution. Any source of law, if inconsistent with the Constitution, is null and void to the extent of its inconsistent. Any act or omission in contravention of the Constitution is invalid. The Constitution is the supreme law of the Republic and binds all persons and all state organs at both levels of government. The person may claim or exercise state authority except as authorized under the Constitution. That's the supremacy of the Constitution. The validity or legality of the Constitution is not subject to challenge by or before any court or other state organ. The Constitution is also supreme since it outlines the governing structure of a country and defines the various organs of the government. And you know the organs of the government: legislature, executive, judiciary. So from there, we have just introduced ourselves. What's law? Sources of law, characteristics of law, where law is derived from, definitions of several terms, and tomorrow we shall proceed with our lesson. And tomorrow we shall start another new topic. Topic number 2. That is law of persons. So revise what we have written. Those notes, they are self-explanatory. Read, reread, let them stick in your head, be in your fingerprints. Let's meet tomorrow. For any question, please hit me in the comment section. And also, don't forget to follow me at Nestor's Entertainment. Nestor's Entertainment. Tell your colleague, neighbor, friend, relative, anybody who is pursuing CPA, ATD, comes. Let's pass together. We can do this. Thank you for now.